Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineered. Good day to all the viewers, to all the students, and to anyone else who might bump into this YouTube account. Again, I'm Attorney Bendrick Marali.
And I'm Attorney April Uy.
And we are here to continue discussing the rest of the topics under the nature and effect of obligations. Sinabi dyan na legally non-existent, hindi ibig sabihin na abolish na yung ano na to, yung batas na to, kasi pwede itong i-revive yung batas na yan. So anytime. But ngayon, again, legally non-existent kasi hindi applicable yung batas na. Now, let's go to Article 1176.
So the receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid.
And the receipt of a latter installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have been paid. So may tinutukoy dito na presumption.
May nabanggit na naman na presumption. Lagi natin niyang ginagamit yung presumption. So let's define the term presumption. So presumption is the inference of fact not actually known arising from its usual connection with another which is known or proved. Inference of fact.
So example nga niyan, attorney is halimbawa, si D or debtor, humiram siya or nagborrow siya ng 1,000 pesos.
Halimbawa ako, nangutang ako ng 1,000 kay Attorney Marali.
Okay. And
later
si
on, ako,
Attorney
si debtor, nagpakita ako ng receipt na may perma ni Attorney Marali. So, the fact not actually known is the payment by D.
So, ang established fact lang dun is that may in-issue nga akong resibo, pero hindi malinaw kung ano nagbayad si Attorney.
Kung may actual payment ba talaga. Pero nagpakita lang ako ng resibo.
Okay. So, in that case, since the fact nun is the possession of attorney or the debtor of a receipt which is signed by me, the creditor, then the presumption is that the obligation has been paid unless proved otherwise by me or the creditor, as for example, that the debtor, attorney, forged the signature of me, the creditor, in the receipt. Kasi nga naman, logically, bakit ka naman mag-i-issue ng resibo doon sa debtor mo acknowledging the receipt of the payment thereof kung hindi naman talaga siya nagbayad?
So, kapag nagpakita ko sa'yo ng resibo, bayad ko na yung 1,000, ito yung resibo, may perma mo. So presumption ay bayad na. There is presumption of payment.
But the same is irrebuttable presumption because ako as a creditor, pwede kong i-rebut yun. What can be my counter-argument?
Forgery.
Pwede finorge ni attorney Uy na ginahan niya lang yung pirma ko. But the burden of proof is on me. So I allege that she is a forger, so I must prove that she actually is a forger. Okay? But then again, material to the topic is that the presumption, na bayad because of the issuance of the receipt. And again, nabanggit ko na rin naman yung rebuttable presumption. There are two kinds of presumption. So ano ba yan?
And rebuttable or disputable.
Can you distinguish, attorney Uy, kung ano ba yung difference niya?
So, conclusive presumption is one in which cannot be contradicted, like the presumption that everyone is conclusively presumed to know the law. Paulit-ulit tayo dyan.
Article 3 of the Civil
Code.
Yes.
How about yung disputable or rebuttable presumption? One which can be contradicted or rebutted by presenting proof to the contrary, like the presumption established in Article 1176.
Alright, so take note of the difference. No, yung isa hindi pwedeng i-rebut, yung isa rebuttable.
Yes.
Okay? So, bigyan ulit tayo ng example.
Yes, example.
Si
BOC the amount of 10,000 pesos with interest at 12% a year. C issued a receipt for the principal, meaning nag-issue lang ng 10,000 pesos.
Na resibo.
Oo, na resibo. Hindi kasama yung sa interest. The interest was not referred to in the payment whether or not it has been paid. Ngayon, Ang situation dito, si C, nag-issue ng resibo na ang nakalagay lang doon, yung amount lang ng principal ang binayaran, yung 10,000 pesos. So, it is presumed that the interest has been previously paid by B because normally, the payment of interest precedes that of the principal.
Proceeds. Ibig sabihin, dapat nauuna, no, customarily sa practice, unang binabayaran ang
interest
bago ang principal. So, but that is not a conclusive presumption because that's a mere disputable presumption and the same may be overcome by sufficient evidence that such interest has not really been.
So, kaya halimbawa, dun sa nung nag-issue si C ng resibo na ang binayadan ni B is yung 10,000 pesos na principal, ang presumption doon, bayad na din niya yung interest.
Yun lang yan.
Oo. Pero, pwede pa rin naman na i-rebut ni C na hindi pa bayad yung interest. Oo.
So, siguro just a tip or a piece of advice sa mga magiging creditor dyan, kung marami kayong pera, nagpapautang kayo, pagdating sa bayaran, make it clear, no, na kung para saan yung payment na yun.
Yes.
And kung halimbawa, hindi nyo alam kung ano yung rule dyan, nililinaw namin ngayon na ang rule dyan nga, isang presumption is that unang binayaran
yung interest.
ang interest. So,
dapat una muna yung interest.
para pag di na kayo magkaroon ng dispute pa, unahin nyo na pabayaran yung interest bago yung principal.
Halimbawa, 10,000 pesos as payment for interest.
Okay? So, for another example, halimbawa si E, no, is a lessee in the apartment of R. Pag sinabi nating lessee, yun yung nagre-rent, nangungupahan sa apartment ng ating may-ari na si R. And E is paying 5,000 pesos rental a month, no?
5,000 yung renta niya.
Yes. However, si E, he failed to pay the rent for the months of February and March. So, alam mo na minsan nagigipit.
Dahil siguro ng pandemic. Pero February, March, hindi nakabayad.
Pumutok yung ta.
Oo, pumutok. Kasi pandemic.
Sunod na, hindi nakabayad. So, in that case, however, nung April, si E nagbayad ng 5,000. Nagbayad siya ng monthly rent kay R. At ito naman si R, nag-issue siya ng receipt that the payment is for the month of April. So, kahit hindi pa
ibig
nabayaran
sabihin ba
February,
nun, Attorney Marali,
yes,
nabayadan na ni, dun ba sa pag-i-issue ng landlord na nakapagbayad, na nagbayad yung nangungupahan ng 5,000 for the month of April. Ibig sabihin ba nun, nabayadan na niya yung February and March?
Well, there is a presumption. And the presumption therein is that the rents for the months of February and March had already been paid. Ano yung reason doon? Kasi this is in accordance with the usual business practice whereby prior installments are first liquidated before payments are applied to the later installments. And logic pa din eh, kung hindi pa naman, kung ikaw yung landlord, hindi pa naman yan bayad ng February and March, tapos nagbayad ng April, eh bakit mo ilalagak yung bayad ng April? Eh alam mo dapat unahin yung February. So kaya nga, kung careless ka, the presumption would run against you. Ang presumption is that
bayad na. Pag naningil ka tuloy dun sa pinapaupa mo, tapos ibibigay sa'yo, teka lang po, nakabayad na ako April, di ibig sabihin, nakabayad na ako ng February, March.
Sasakit yung ulo mo dyan.
Ikaw ngayon, ang may burden of proof na ipakita na hindi pa talaga siya nakakabayad.
So take note of that, sa mga landlords dyan, sa mga may-ari ng apartment and all. No? Again, this presumption is merely disputable kasi pwede mo naman ng promebahan na hindi pa talaga siya bayad ng February and March. Okay.
Yes.
But these presumptions in Article 1176, there are instances na hindi yan nag-apply.
Correct.
So, kailan ba, for example, Attorney Uy?
So first, with reservation as to the payment of interest. So the presumption established in Article 1176 do not arise where there is a reservation as to the interest or prior installments. The reservation may be made in writing or verbally.
Okay. Kung may reservation,
hindi pa bayad sa interest.
And the same must be in writing or verbally. Pero yun
dapat may agreement.
Pangalawa, when the receipt for a part of principal, a receipt for a part of the principal without mentioning the interest merely implies that the creditor waives his right to apply the payment first to the interest and then to the principal. And only when the principal is fully receipted for, may failure to reserve the claim for interest give rise to the presumption that said interest.
Kagaya kanina, sabi 10,000 yung utang na principal, tapos meron ka lang na 12% interest. Ang ginawa ng debtor, nagbayad ng 10,000. Ang nilagay ni creditor sa resibo, 10,000 ang binayad. So, hindi mag-a-apply ang presumption kung ang ibinayad ni debtor ay, for example, 5,000 lang. So, there is no presumption na binayadan na niya yung interest. Kasi hindi naman part lang ng principal ang binayadan niya. Mag-a-apply lang yung presumption kapag yung full amount of the principal has been paid and with no reservation as to the amount of interest.
So that's the second situation wherein the presumption will not apply. And the third one is when the receipt is without indication of particular installment.
Yan, ito naman, ang situation naman nito, kanina, dun sa example natin, February, April, hindi nagbayad. February, March, hindi nagbayad ng upa. April, nagbayad. Nag-issue ng resibo na nagbayad ng month of April, 5,000. Sabi, ang presumption, nagbayad na din siya ng February and March. Pero, hindi mag-a-apply yung presumption kung ang inilagay lamang ni landlord, for example, payment of 5,000 pesos, walang month, hindi ni-specify. Ibig sabihin, bayad niya yun for February.
So, see, on the part of the creditor, on the part of the landlord, it's safer not to indicate kung para sa ang kabayaran nun. Kasi
basta nagbayad lang ng gayo.
Para hindi mag-run against yun yung presumption. Alright?
See, dun lang sa konting month na inilagay mo,
just a piece of word, no? Ang laki na ng repercussion nun sa'yo.
Yes.
So, take note of that. Pang-apat, as regards payment of taxes, of course, hindi applicable din ang presumption under Article 1176. Kasi nga, there is no presumption that previous taxes have been paid by the payment of later ones.
No? Ay, hindi ibig sabihin na nagbayad ka ngayon ng tax, bayad mo na din yung previous tax mo. Kasi hindi mo mauutahan ang government.
And lifeblood doctrine. So, yes. Mapunta pa tayo sa usapin ng taxes. Alright, panglima is the non-payment
is proven. Kapag na-prove mo na hindi pa talaga nagbabayad, di na presumption mo nag-apply. Kaya kanina, na-prove mo na yung 10,000, hindi doon kasama yung interest, hindi mag-a-apply yung presumption.
Because a presumption definitely cannot prevail over a proven fact. Okay? Presumption lang yan eh. Alright, let's proceed with Article 1177.
Ito naman, the creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. So, yung Article 1177 naman, it talks about the remedies available to the creditors for the satisfaction of their claims.
So, in case the debtor does not comply with his obligation, then the creditor may avail himself of the following remedies to satisfy his claim.
Yes,
so, remedies ito sa kanya.
Itong remedies na babanggitin natin in the order of preference na naman.
Yes, in order of preference. So, ang top of the preference is that exact fulfillment or specific performance with the right to damages. So, kung pwede naman na i-perform pa rin yung obligation, no? Or exact fulfillment nga, kung ano yung original na obligation niya, of course, with the right.
Yes. May utang ka, di ba, may utang kang 400,000, may pambayad naman may pambayad ka naman. So, si creditor, ang remedy lang niya is to demand the amount of 400,000 with the right to damages. Yun lang.
Now, for example, hindi na available yung
for example, dun sa utang na 400,000, wala kang ganong kalaking pera, ang pera mo lang yung 100,000 pesos.
So, ibig sabihin ba nun, forgot na
okay
yung 300,000?
Keep the change.
Payagak si creditor. Hindi, sinasabi ng batas, may pangalawang remedy si creditor, pwedeng mag-pursue siya ng leviable property of the debtor. Ibig sabihin ng leviable, pwede mo yung i-attach, no? I-ask yung court na i-levy yung property nung debtor para pwede yung ibenta sa auction sale, yung proceeds nun
It will be applied
dun
to
sa
the debt.
obligation
to the loan.
debtor, to the loan. But take note guys na yung leviable property,
Meron
yung
yan
mga-
sa rules of court.
Yes, yun yung mga hindi exempt from attachment under the law kasi may mga exempt nga from attachment, especially yun ba yung isang bahay mo, yung bahay na meron, hindi ba kasi mawawalan naman ng tutuluyan yung debtor na meron.
Yes.
Okay?
For example, meron kang 400,000 yung utang mo.
Yes.
100,000 lang ang kaya mo
Available
i-buy na cash.
cash.
So si creditor, sabi niya, sige, akin na yung cash mo. Kulang pa rin. Tapos meron ka naman sasakyan. Ang sasakyan mo worth 200,000 for
Kulang pa
example.
rin, no?
O,
Pero
kulang
sige,
pa din.
okay.
Pero sige,
Pwede
sabi,
gawin.
yun naman, leviable. Pwede naman siyang ibenta. So, ang ginawa ni creditor, nagpunta kay court, tapos yung
Attach.
sasakyan, pinatouch yung sasakyan, ginawa, ibinenta, yung proceeds na 200,000 will be applied to your outstanding balance. O, di ba may balance ka pang 300,000. O, 200,000 yung loan. Yung 200,000 yung proceeds so napagbentahan. So, i-apply yun. So, may 300,000 ka ng payment. Hindi pa rin sapat doon sa
So may
utang mo na
100,000 pa. So in that case, halimbawa, di wala ka nung ma-pursue na
wala na.
property na pwedeng i-attach. Meron pa bang pwedeng gawin si creditor? Ang sinasabi ng batas, yes, meron pa. Kasi after having pursued the property in possession of the debtor, the creditor may actually exercise all the rights and bring all the actions of the debtor except those inherent in or personal to the person of the latter, such as the right to vote, to hold office, to receive legal support, to revoke a donation on the ground of ingratitude, etc. Ibig sabihin lang yan, pwedeng, yun na.
For example,
exercise ng
ito
rights.
naman, for example, ako, okay na yung nakapagbayad akong 100.
100,000,
Yung 200,000 sa car. Ito naman number 3, for example, ako, meron akong pautang kay Attorney Maralit. Ako ay creditor ni Attorney Maralit for 50,000 pesos. O may utang sa akin si attorney. Nakita ngayon nung pinagkakautangan ko, yung creditor ko, nakita niya ngayon na may pautang pala ako kay Mr. Maralit. So, yung creditor ko, pwede niyang habulin si Mr. Maralit at sa kanya ibayad yung utang niya sa akin.
In short, yung debtor ng debtor mo, pwede mong habulin para sa halip na bayaran ng debtor mo, yung utang niya dun sa debtor mo, sa iyo bayaran, direkta na sa iyo. So halimbawa nangyari yun, attorney,
pwede din yan, kalimitan din yan sa mga bank accounts, ginagarnish.
Garnish naman yung tawag
garnish
doon.
naman,
Kung kanina yung property ay nililevy, ito naman ginagarnish yung
Ito naman kasi, may kasali na ditong third person. Yun yung sinasabing, after having pursued the property in the possession of the debtor. Ano yung property in the possession ko? Yung pera ko, yung kotse, the leviable property. Exercise all the rights and bring all the actions of the debtor. Edi, ikaw, mangongolekta ka ngayon sa kanya. Siya, magbabayad na siya sa'yo ng 50,000. So, for example, nabayad niya yung 50,000, so 350, may kulang pa rin na 50.
Kulang pa 50,000.
And may exception din pala doon. Attorney Maralit.
Exception nga dyan is, hindi mo, as a creditor, hindi mo pwede syempre sakupin yung mga karapatan ng debtor mo na very personal sa kanya. Halimbawa, the right to
receive legal support. Paano yan? Halimbawa naman, tatay ko si Attorney Maralit. Ako ay minor, for example. Si Attorney Maralit ay may duty na i-support ako financially. Then, hindi pwede na yung financial support na matatanggap ko from Attorney Maralit ay sasabihin mo na sa iyo ibigay kay creditor. Hindi pwede yun. Kasi that is inherent or personal to the person, to my person. Ganun, hindi pwede. Yun yung exception. Pero kung creditor ko siya, pwede. Pero kung I have the right to receive legal support from him, hindi pwede yun.
Alright. So So, ang nangyari na dyan sa ating example, attorney, nakakolekta ka na ng 350,000,
Yes,
may
so,
50,000 pa ang kulang. What if ganito, ang ginawa nung debtor, nung nalaman niya na naghahabol na, ito, common na nangyayari sa totoong buhay ha. Nung,
Ako yung debtor eh.
Halimbawa, si attorney, alam niya na naghahabol na nga si,
yung creditor ko.
Ako ba, creditor?
Hindi, yung
iba,
si third
may ibang
person.
creditor, third person. So, alam ni attorney na naghahabol na nga yung creditor. So, ang ginawa niya, alam niya kasi meron pa siyang
lupa.
May lupa siya na sakahan na worth, let's say, 300,000 pesos. So, ang ginawa niya, knowing na pwedeng habulin din ni creditor yung lupang sakahan na meron siya, ang ginawa niya, inunahan ng ibinenta ngayon. Ibinenta sa akin halimbawa.
Oo, binenta ko naman ulit sa'yo.
So, ngayon, nalaman ni creditor na si Attorney Uy, binenta nga yung lupa na yun. Attorney Uy, meron bang pwedeng gawin si creditor as regards na bentahan na nangyari?
Oo, yun na yung sinabi.
The
creditor or my creditor may ask the court to rescind or impugn acts or contracts which the debtor may have done to defraud him when he cannot in any other manner recover his claim. So yun nga, 350,000, may 50,000 pa akong balance. So, wala na. Number 4 na tayo. Nakita nung creditor ko na nakita nung creditor ko na nagbenta ako ng lupa para matakas ko sa kanya.
Yes.
Meron ako dong intent to defraud.
Yes.
So, ang remedy doon, nung pinagkakautangan ko, is to go to court and ask the court to rescind or impugn the contract between the two of us.
Yes, and in that case, if ever the same will be granted by the court, the proceeds will be given, of course, to the creditor. Pero halimbawa, attorney, di ba na ang ginawa, in-impugn nga, kinancel na yung contract, ay ang proceeds na 300,000. Ano mangyayari sa 300,000? Lahat ba yun ay ibibigay din dun sa creditor to the point na magiging, to the point na 350 plus, magiging 650,000 na yung
Hindi naman. Siyempre hindi. Yung 50,000 lang nakakulangan, yun na ibibigay. At yung 250, ibibigay mo sa akin at ibibigay ko naman doon sa pinagbilhan ko.
Yes.
Hindi
naman pwedeng kumita.
Hindi naman pwedeng kumita.
Yung creditor.
50,000 lang.
Yung sapat.
Kung magkano lang yung balance, yun lang.
And again guys, the debtor is liable with all his property, present and future, for the fulfillment of his obligations subject to the exceptions provided by law under Article 22.
Kasi nga, sabi nga natin, doon sa leviable property, merong exceptions dyan na hindi talaga pwedeng ibenta, hindi pwedeng i-attach ng court. Okay?
Alright, so to the students, we've given another example in your module. You can revisit it para mas makita ninyo yung kahalagahan ng article na ito. Okay? Note guys na in this case, yung last remedy na meron tayo, yung nabanggit nga ni Attorney Uy na pwedeng i-impugn or i-cancel yung mga contracts entered into by the debtor to defraud the creditor, they can only be resorted to only if the creditor could not collect in full
his credit. So, ibig sabihin lang, yung creditor must first exhaust the properties of the debtor or subrogate himself in the latter's transmissible rights and actions. So, kagaya nga kanina, sinabi ko, kung may 400,000 naman ako, no need to go between 2, 3, 4, 2, 3, 4. Doon lang sa number 1, sa exact fulfillment with damages, sapat na. Hindi mo na kailangang mag-levy. O kaya naman, may pera nga akong 400, tapos ang gusto mo, ay, ayoko ng pera, gusto ko yung kotse mo, ang event mo, hindi pwede.
Exact fulfillment na.
Una muna, sunod-sunod ngayon, 1, 2, 3, 4.
Hierarchy. Okay? Take note of that.
Yeah.
Alright, so we're now into the last article under the nature and effect of obligations, and that's Article 1178. Yes, last na to. And mag-module test na kayo. I'm just kidding. Alright, 1178, subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. So, ano ba sinasabi niya? Transmissibility of rights.
So, ang general rule natin, all rights acquired in virtue of an obligation are transmissible. Ibig sabihin, pwede mong ipasa. All rights.
But may exceptions, syempre, to the general rule. The first one is
when prohibited by law. So, ibig sabihin, kapag pinagbabawal ng ang general rule nga, pwede mong ipasa yung iyong right acquired by virtue of an obligation. Pero kapag ito ay pinagbabawal ng batas, batas ay hindi pwede. No transmissibility of rights.
So, example nga niyan is yung rights in the contract of partnership, agency, and comodato. Because these are purely personal in character.
Oh, sa partnership ba, Attorney Maralit, bakit bawal yung transmissibility of rights?
Kasi when it comes to the contract of partnership, no, there are two or more persons who bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. And sa partnership,
upon the death of the partners, it will result to the dissolution
of
the partnership.
Kasi take note guys na ang partnership is highly
fiduciary,
no? Fiduciary nature.
Correct.
Hindi yan basta-basta dapat nilalabag. So such that, alam kami may partnership kami ni attorney or kung may isa man sa amin na let's say mauna
makasama si
Lord. Hindi pwedeng, halimbawa ako na lang, namatay ako, halimbawa lang hindi pwedeng i-transmit ko yung rights na meron ako sa partnership dun sa aking anak
or asawa.
Kasi nga highly fiduciary.
Kasi yung partnership namin is highly fiduciary and purely personal in character.
Yes, alright. Next, by the contract of agency.
By the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. Sa agency naman, ito kagaya dito ng partnership, dito parehas silang fiduciary in nature. At isa pa, yung for example, hindi ko rin pwedeng i-transmit sa iba. I'm the principal, siya yung agent ko. Yung agent ko, hindi niya pwedeng i-transmit yung rights niya and by virtue of our contract of agency. Ganun din naman ako as principal.
Unless consented.
Unless may, unless may consent.
Right. With the contract of comodato naman, one of the parties here delivers to another something not consumable so that the latter may use the same for a certain time and return it. And in this case kasi, ang comodato guys is essentially gratuitous. Halimbawa, pinahiram lang sa iyo yan.
Yung book mo ng OBLICON. Pinahiram sa iyo, comodato yun. Kasi non-consumable naman yung book.
So, hindi mo pwedeng ipasa yung right mo dyan sa comodato.
Pwede mo siyang, nakalagay pa dyan, so yung book ay pwede mong gamitin for a certain time and to return it. So, dyan may bailee, may bailor. So, hindi rin yan transmissible kasi yung hiniram mong book, hindi mo naman pwedeng ipahiram din sa iba. Except dun lang sa iyong immediate family members. May mga exceptions dyan.
Alright, so, take note of that, guys. Okay? So,
yun ay exception under the law. At itong naman padalawa, ito yung exception sa transmissibility of rights. When prohibited by stipulation of the parties.
When prohibited by stipulation of the parties, like the stipulation that upon the death of the creditor, the obligation shall be extinguished, or that the creditor cannot assign his credit to another, and the stipulation against transmission must not be contrary to public policy. Okay.
So yun, laging kasama yung stipulation of the parties, 'di ba? Sa mga exception. Kasi nga the stipulation or the agreement or the contract is the law between the parties. So kailangan nga lang para ma-prohibit yung transmission of rights, kailangan ito ay expressly stipulated.
Yes,
it cannot be implied.
Yeah, since such stipulation is contrary to the general rule, hindi nga siya easily implied, no? And it must be clearly proved, or at the very least, clearly inferable from the provisions of the contract itself. So on that note, guys, we've just finished discussing all the codal provisions from Article 1163 to Article 1178 of the Civil Code as regards the nature and effect of obligations.
Sana madami kayong natutunan.
Yes.
Pakatutukan ninyo itong chapter na ito, itong mga discuss dito kasi napakahalaga nito.
Agree. And you can apply that not just academically but also in the
real life situation.
Real life situation. Okay, so on that note, guys, we thank you for listening. I hope that you will continue to support and subscribe in our online video lectures. This is for your benefit so that you can access it at your most convenient time in this
flexible time. Pwede nyo i-replay kahit paulit-ulit.
Yes, para mas mag-sink in sa inyo kung ano yung sinasabi ng provisions ng batas. And if you have any questions or queries as regards to topics that we've discussed, don't hesitate to comment down below your questions or message us. And we will try our best to answer all those questions in the next video lectures that we will be uploading. So again guys, this is been Attorney Bendry Imarali.
And Attorney April Uy.
Lagi nagsasabi na ignorance of the law excuses no one. Thank you so much. See you soon.